This interview was with Craig Oliver. He is an attorney who attended Harvard Law School and practices labor and employment law. Craig will discuss some of the legal issues that arise involving people with cancer and their employers. Because laws vary and are too complex to cover them thoroughly in this interview, remember to consult your own counsel whenever you have questions about the rights and duties of employers and employees.
One of the laws that's been passed in the past 15 years that affects people with disabilities in the area of employment discrimination is the Americans with Disabilities Act, or the ADA. It applies to employers with 15 or more employees, and it protects employees and applicants for employment from discrimination. In order to be covered under the ADA, an employee or applicant must be what's called a qualified individual with a disability. That means that the employee or applicant must be able to perform the essential functions of the job, and the employee or applicant must have an impairment, physical or mental, that substantially limits one or more major life activities. By major life activities, we mean things such as seeing, hearing, walking, breathing, or working. It's important to note that the ADA protects not just employees, but applicants. An employer may not refuse to hire a qualified individual with a disability because of that person's disability or because the employer erroneously regards the person as having a disability. Under the Americans with Disabilities Act, an employer may not ask an applicant for employment whether the applicant has any disabilities. The employer may, however, ask the applicant if the applicant can satisfactorily perform the essential functions of the job. If the applicant knows that he or she cannot satisfactorily perform the essential functions of the job unless an accommodation is made, then the applicant at that point has an obligation to notify the employer that he or she can perform the essential functions of the job, but with a reasonable accommodation. At that point, the employer may not discriminate against the applicant, but may ask the applicant what reasonable accommodation would be required. The Equal Employment Opportunity Commission refers to this as an interactive process, where the employee has the first obligation to notify the employer of his or her need for a reasonable accommodation, and the employer has a corresponding obligation to engage in a dialogue with the applicant for employment to determine whether the reasonable accommodation would be practical for that particular job. Additionally, if an employer hires an applicant with a disability and that applicant requires a reasonable accommodation in order to be able to perform the essential functions of the job, the employer must provide a reasonable accommodation to the applicant. A reasonable accommodation could be a change in work hours or work schedule. It could also be a change in the minor or non-essential functions of the job. The Americans with Disabilities Act protects not only individuals who actually have a disability, but also individuals who the employer erroneously regards as having a disability and individuals who have a record of having a disability. An applicant for employment who is not presently disabled has no obligation to notify the employer that he or she has a record of having a disability. If the employer, however, discovers that the applicant has a record of disability or that an employee it is already hired has a record of having a previous disability, the employer may not discriminate against the employee or applicant based upon that record. It may not discriminate against the employee or applicant in terms of hire, promotion, salary, discharge, or other terms and conditions of employment. Another act that affects employees is the Family Medical Leave Act. That act provides up to 12 weeks of leave in a 12-month period for qualified employees. In order to be a qualified employee under that act, an employee must work for an employer that has 50 or more employees. The employee also has to have worked for the employer for at least 12 months and has to be essentially a full-time employee. That is, the employee has to have worked at least 1,250 hours in the immediately preceding 12 months. What is a serious health condition under the FMLA? Well, it can be a couple of things. One thing it can be is a health condition that, if not treated, would require the employee to miss at least 3 days from work. It also could be long-term or chronic conditions that do not require 3 or more days of absences from work, but do require periodic treatment. The important thing to remember there is the leave that's protected under the Family and Medical Leave Act, or the FMLA, does not have to be taken in a single block of time. So if an employee has a serious health condition under the FMLA and has regular periodic doctor's treatments, the FMLA requires the employer to grant the employee leave for those periodic treatments.